This is a book summary and review of the Little Book on Legal Writing by Alan Dworsky, and we are looking at Chapter 12, Office Memoranda. The chapters so far have covered legal writing piece by piece, a word or phrase at a time. This chapter explains how to put all the pieces together in an office memorandum. Oh, how cool! Called an office memo for short. When you get your first law job, an office memo will probably be your first assignment. Your boss will ask you for a memo answering a particular legal question related to a client situation. This chapter explains how to write one. Interesting, this is pretty cool. First, do a first draft early. The advice in this chapter on the structure of a legal analysis is based on the assumption that you've taken care of the content by adequately researching and analyzing issues. But don't wait to start to try writing until you feel your analysis is perfect. The act of writing is often an important step in clarifying your thinking. While the analysis is swirling around in your head, it's hard to see gaps in logic and flaws in organization. When you make the analysis stand still on paper, the defects become apparent. Next, be objective in an office memo. Although your answer is an office memo to the question you've been asked should be objective, that doesn't mean you can't take a stand. Let me read that again. Although your answer is an office memo to the question you've been asked should be objective, that doesn't mean you can't take a stand. Objectivity refers to the process by which you reach your conclusion. You can reach a conclusion that your client will win or lose as long as you reach it by analyzing the facts and the law from the standpoint of a neutral observer. Anticipate how a judge or jury would see the case and try to predict the result. Next, the format of an office memo varies. Unlike the format of a brief, the format of an office memo is not dictated by any rule or statute. In law school, the recommended format usually includes a question presented, a statement of facts, a discussion, and a conclusion. Sometimes it includes a brief answer after the question presented. Oftentimes it omits brief answer but places the conclusion after the question presented instead of at the end. In school, follow the format used in legal writing text or course. Next, include a thesis paragraph unless it would be redundant or clumsy. The first paragraph in your discussion generally should introduce and summarize the analysis that follows. When it does, it's called a thesis paragraph. It is to the discussion what a topic sentence is to a paragraph. If possible, it should contain your main conclusion, the governing rule, and the decisive facts. Dude, this is actually a pretty good chapter because it's talking about how you summarize stuff. Next, discuss issues one at a time in a logical order. If you have two or more issues or sub-issues, discuss them separately. Complete one before moving to the next. Next, organize the discussion of each issue with capital C, capital R, capital A, capital C. Crack, pronounced C-rack. Oh, it's not pronounced crack, it's pronounced C-rack. C-rack, to avoid any unwanted connotations, is a tool to help you organize the discussion of a legal issue. This is very interesting. I want to read more about this. It's a slight variation of the better known IRAC. Oh, dude, I've heard about IRAC. That's capital I, capital R, capital A, capital C. IRAC stands for Issue, Rule of Law, Application of Rule of Facts, and Conclusion. It's designed to remind you to cover those four elements in that order. The only difference between CRAC and IRAC is that CRAC starts with a conclusion instead of an issue. Knowing the conclusion at the start helps the reader understand the analysis, just as knowing who did it in a mystery novel makes it easier to spot the clues. Look at that, dude. How interesting. Dude, is that the rest of this chapter? Next, explain the rule of law before applying it to your facts. Oh, how interesting. So we have to determine what the law is and then talk about how it applies to our facts. I'm not even going to read that paragraph because that's pretty self-explanatory, right? Next, give enough facts about each case you cite to make it meaningful and useful. Look at that, dude. That's so helpful. Next, first give the analysis supporting your conclusion on an issue, even if it's against your client, then discuss counter arguments. This is just interesting. Once again, I'm not a lawyer. I'm not going to be arguing stuff in cases, but we're going to read this. In the sample office memos in the legal writing text I've seen, the conclusions have always been in favor of the writer's client. The discussion of Sobel's case in example 179 illustrates that a conclusion can also go against the writer's client. After the analysis supporting your conclusion on an issue, go on to discuss any counter-arguments. Gathering your counter-arguments at the end of each issue prevents your analysis from resembling a ping pong match and giving the reader a sore neck. Use this strategy. The final paragraph in example 179 might be expanded as follows. It's a huge example. Look at this. It's like so big. We're not going to go through that example. We're going to keep reading. Next, track the language of cases and statutes when you apply them to your... Excuse me. Track the language of cases and statutes when you apply them to your facts. Next, use transitions that point both ways. Transitions are the glue that holds your discussions or arguments together. They come in all sizes. They can be one word, such as however or furthermore, or they can be a full sentence or more. Whatever size a transition is, ideally it should point both ways. It should tell the reader where you've been and where you're going, and by doing so, tell the reader where you are in the structure of your discussion or argument. Next, use subheadings generously even though they aren't required. In an office memo, only main headings like discussion, that's in all caps, are required, but you should use subheadings whenever they're helpful. Next, don't put new material in your conclusion. Don't do that. The new material should not be in the conclusion because the conclusion is it's the summary of everything that's beneficial to your argument. So that's actually a pretty good point. Next, express your conclusion as precisely as possible. Oh, how interesting. See, because I always thought you wanted generalities for the sake of making your argument more acceptable to a wider audience or something like that. But I think in legal theory, you actually want to have as specific of a conclusion as possible. And so that's kind of the point of that. And you guys, that's the end of the chapter. That's the end of chapter 12, Office Memoranda. All right, bye. Remember, kiss that like button with your finger, kiss that subscribe button with your finger, and if you're interested in supporting Miyakizilla work, go to the Miyakizilla Patreon page. All right, bye. If you're an independent and you care about being represented, even more so if you're frustrated and you feel like you're not represented, the whole point of this project, the whole point of this content is to help independents feel like they've got a voice, feel like they've got somebody fighting for them. And so that's what this content's about. If you're interested in supporting this, go to the patreon.com/Miyakizilla Patreon page and consider supporting us for $2 a month. That's all. All right, thank you very much. Bye.